Welcome to those of you that have joined us. We have just opened the link, so we're just waiting for a few minutes to allow everybody to join before we start. Welcome to those of you that have joined. We have just opened the link, so we're just waiting for a few minutes to allow everybody to join before we start. Welcome to the Five Stone Buildings webinar programme. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Whilst we are waiting, I shall just remind you of the house rules. So just to remind you that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions in the Q&A box at the bottom, and our speakers will try to come to them at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that the speaker will not identify you in their response. And just to remind you that we now have a webinar section on the Five Stone Buildings website, which is where you'll be able to find a copy of this webinar and any previous webinars. I will now hand over to Jordan and Rose.
Hi there, thanks Joe. Well, thank you everyone for coming. I am Jordan Holland and I'm here with Rose Fetherstonhaugh. We are going to be discussing today one of the most interesting topics that you can possibly imagine, which is the disclosure pilot, which now applies in the business and property courts. Because we're at the Chancery Bar, I think Rosie and I still regard this as rather new. And we are hot off the press because it's only been in operation now for about 2 years. So, but it is...
You're stealing my thunder with the slide, Jordan.
I know, I thought I'd do that deliberately. But but it is something that actually still is bedding in. And I think it's good to talk about it now because it's finally started to kind of get into the brains of practitioners, etc. But it does continue to throw up pretty difficult problems and also satellite litigation, which we all love, of course. So I'm going to hand over then to Rosie to start.
Thank you very much, Jordan. Well, as Jordan has already said, it's kind of new-ish is how I put it, because it was brought in starting in 2019. But I think in relative terms, we can say that that's pretty new, particularly because I think it still throws up a lot of difficulties where, in terms of its application, and as Jordan says, is still bedding in. So what is it? When does it apply? It applies to the business and property courts, the High Court, that is. It doesn't apply yet to the county court, although slightly threateningly, paragraph 1.2 of the pilot says that this might be reviewed. So I suppose watch this space and keep an eye out. I can only imagine the drama that would ensue if it did apply to the county court, which perhaps we might discuss in a bit. So why was it brought in? It was apparently introduced as a result of concerns identified by the snappily named Disclosure Working Group, that the existing scheme wasn't cost effective and was basically not proportionate. It's not simply a rewrite of Part 31 though. It is basically intended to be a new and I was going to say vibrant scheme, but I don't know if that's the right word.
I think vibrant might be pushing it a
vibrant might be pushing it a bit far. But it is a new model for the new business and property courts. It's currently in place until 2022. although even if it stops then, it's not just going to stop dead, it will continue to apply to proceedings to which it applied at that point. And I suspect that it will keep being extended and will eventually be turned into something more permanent. But at the moment, it's referred to as a living pilot that is designed to be responsive to the needs of practitioners. So we are still in a feedback and sort of, one might call it a teething stage, I think. Jordan, could I have the next slide, please?
Yeah.
So this brings us into the why, and I've touched upon this a bit already. There were concerns that the existing scheme, i.e. Part 31, wasn't really working well. It wasn't cost efficient, it wasn't proportionate, it was leading to too much cost and expense in legal proceedings. And as I've said, this new scheme is not simply designed to be a reiteration of what was there before, although, I mean, of course, it should be said that Part 31 does still continue to apply, and we'll touch on that. But it is essentially, as it says in this authority, well, as the Chancellor, as he then was, said in this authority, it's intended to operate along different lines driven by reasonableness and proportionality. What we're going to come on to in a bit is whether that's actually being borne out in practice and whether that works.
I love that you put that does it in purple.
I know, just our 5 stone buildings colour. Just to
without a question mark.
Yeah, sorry about that. So it is supposed to apply to all cases within the business and property courts, whether you've got your probate claim worth 200,000 or your high value commercial litigation worth 100 million. And you might think, well, it's a bit difficult to produce a sort of a one size fits all pilot, and that's again something that we might touch upon later. But moving on to the third point in the slide, along with this culture of proportionality, the whole idea about the disclosure pilot is that it's supposed to work in a fairly simple and cooperative way. And in particular, the recent authorities, again, we've got Sir Geoffrey Voss popping up again, saying that the parties are not supposed to take an unduly complex approach. You're not supposed to get too granular about it, to use some sort of, I suppose, management consultancy speak. The parties are intended to cooperate, and we all know how difficult that can be sometimes, and work together. And I think that's one of the difficulties with the disclosure pilot, because the provisions are so complicated and involved that if you don't have the parties and their representatives being on the same side about how it works and how it should work, then that can throw out real difficulties in practice. But the courts are consistently encouraging us not to do that. In much the same way as with relief from sanctions, the parties are discouraged from taking overly technical points with the stick that they might incur adverse cost consequences if they do take technical points. So cooperation, proportionality, they're the buzzwords when it comes to the disclosure pilot. Can I have the next slide, please, Jordan? Now, this slide rather does what it says on the tin. The disclosure pilot applies to all Part 7 claims within the business and property courts, save for a few defined exceptions at paragraph 1.4, which don't generally come up in our field, i.e. private client. Now, when it comes to Part 8 claims, which do form a lot of our bread and butter work, so 75 Act claims, executor removals, trustee directions, and so on, the disclosure pilot does not apply directly. And that is because Jordan will come on in a moment to speak about initial disclosure, which it kicks in at the statement of case stage. The only statement of case in a Part 8 claim is the claim form, and the disclosure pilot specifically provides no obligation to give initial disclosure with a Part 8 claim form. And the reason for that is that Part 8 effectively has its own scheme for disclosure, i.e. that when you file a witness statement at the outset of proceedings, you exhibit the relevant documents to the witness statement, or at least that's the idea. But that doesn't mean that the disclosure pilot has no role to play at all in Part 8. And in fact, there's a rather helpful disclosure pilot practice note, which comes in the white book just after the disclosure pilot, explaining how it might work in Part 8 claims. And essentially, where you're looking for a disclosure direction in a Part 8 claim, the court will adapt and apply the disclosure pilot, but in a more simplified form. So although you're expected to still identify issues for disclosure and the relevant model for disclosure, thankfully, Chief Master Marsh says that practitioners won't be expected to comply with the full procedure. So the rather awful disclosure review document, which we will come on to in a moment. Now, I think that is all for that slide. And Jordan's going to speak to you about initial disclosure.
Yeah, so initial disclosure. I think initial disclosure is what people have hated so very much about the disclosure pilot. As of course, back in the old days, you would issue your claim, do your particulars of claim, you would get the defence, pleadings would close, etc., etc., and then you go to the CMC, and then you get an order from disclosure. So you're pretty far into the claim before you had to think about disclosure. Now, quite clearly, you had already looked at documents, because otherwise you wouldn't have been able to do the pleadings. But so what this does, the initial disclosure stage, which applies to all things, it applies at the statement of case stage, is it kind of front ends that process. Rather than just say disclosure will happen once, you have to do initial disclosure without any kind of order or at the statement of case stage. So you're supposed to kind of be freely giving your documents before at an earlier point. As it says, the obligation is to provide an initial disclosure list of documents, so it's still by list, but instead of inspection, you just send the documents straight away. But those documents are described as key documents, which are relied upon in support of your claim or defence, advanced in your statement of case, and they have to be necessary to enable other parties to understand the case they have to meet. And starting them with some of our satellite litigation, although I think, we've already had some satellite litigation, haven't we? We had it in the last slide, but Breitenbach and Canaccord. Now, I think the most interesting part about this judgment is that it is a joint judgment of a High Court judge and a master, which is a very rare thing. It's not, it's not. I mean, it's not totally unheard of, but until very recently, it would be totally unheard of. So yes, it's a joint judgment of Mr. Justice Fancourt and Master K. It's unclear to me why they decided to give a joint judgment. I don't know why. I don't know whether it was one of those triage cases where that they were the two. I don't know. But anyway, they gave a joint judgment. It's not a long judgment. You may feel that you don't need to read it. And certainly Westlaw feels that it doesn't need to even summarise what's in the judgment.
Is there not even a case analysis?
No, there's no case analysis.
That's brutal.
I know it is. It's really brutal. It's just a kind of it's like one of those 19th century cases where there's no case analysis available. Anyway, no. So basically, the only thing that you need to take from Breitenbach is that it is limited to key documents, and key documents are different from documents related to. So, for example, in that case, what it was said is, oh, well, they've obviously pleaded this defence, blah, blah, they pleaded this defence with reference to their internal documentation, otherwise they wouldn't have X, Y, Z, and therefore we should see those as part of their initial disclosure list. And what the court said was, clearly there were other documents, but they weren't key documents within the terminology. So key documents doesn't mean all documents. It just means, or documents that are related to your statement of case. It just does mean key documents. And then that was expanded upon. I say expanded upon, maybe it came first. I'm just looking at that. No, it was expanded upon in Qatar and Bank Haviland SA, which regrettably is a judgment of just a High Court judge, so no master involved, but which said that the initial disclosure stage was very tightly focused, And the whole ambit of the scheme of initial disclosure and disclosure requirement was intended to streamline the disclosure process. So it was unlikely that it required more than, and I quote, really very necessary documents. So key documents are really very necessary documents. I suspect that won't be taken as a gloss, but it does emphasize that what you're looking for here is really only very key documents. And so one should resist the temptation to get into spats at an initial disclosure stage by saying, oh, clearly you've got other documents that you haven't given to us. You could take the view, as when you're giving disclosure, that you would give more extensive documentation, but you don't have to do so. So then the next stage is extended disclosure, although it's not an automatic stage. You're not actually entitled anymore. Back in the old days, of course, you would get to the CMC and you get an order for standard disclosure. Now there's no automatic entitlement to extended disclosure. The only automatic entitlement that you have is to initial disclosure. So of course, whilst I said you might want to resist having a spat about initial disclosure, if you feel that initial disclosure is all you're going to get, then you may want to make sure that you do in fact have the key documents. But the court will only make an order for extended disclosure, only make a search-based order for extended disclosure where it's persuaded that it's appropriate to do so to resolve one or more of the issues for disclosure. And Rose is going to talk about the models in a minute. Unlike back in the day, not all of the disclosure models actually do involve a search-based order. So there's no requirement for an application notice, but whatever happens, the parties are going to be expected to complete what's been described as the fairly onerous disclosure review document. It is a pretty tedious document. I'm not going to go through it now because this talk might be described as pretty tedious anyway, but it's it's that Appendix 2, and you can see we're already up to Appendix 2. The disclosure pilot has, I think, 4 appendices. Does it have more?
I couldn't say off the top of my head how many appendices.
I think it's got 4. It could even have 5.
Oh my
but
God.
You can already see that this new streamlined version of disclosure can seem fairly bewildering at first blush. If you're only seeking an order in respect of models A and or B, then you don't have to complete the disclosure review document, and that's because they're the ones that don't involve a search. They just say, oh, if you've got these documents, basically, can you hand them over? But the extended disclosure generally involves models for disclosure by reference to the issues for disclosure. So basically, you agree your issues. Well, hopefully you agree your issues for disclosure, and then you look you look at each issue and decide what extended disclosure is necessary. And extended disclosure may be necessary in respect to some issues and not necessary in respect of other issues. So if then a party is seeking extended disclosure, the principal thing which the court is going to look at, its guiding light as to whether or not to order extended disclosure, is whether or not extended disclosure. Sorry.
Guiding light.
Guiding light. It's reasonable and proportionate. But of course, then we're told in terms, and I suspect this was to, in fact, avoid satellite litigation as to what reasonable and proportionate meant, we're told in terms in the practice direction of paragraph 6, I think it's 6.4, what reasonable and proportionate means. And in deciding that, you will take into account the nature and complexity of issues in the proceedings. I mean, obviously, if you've got a more complex case, it's more likely that it will be appropriate for extended disclosure. The importance of the case, and that's interesting because and then it says including non-monetary relief. It doesn't say whether that's the general public importance of the case or whether it's the importance of the case to the parties. And I suspect that's deliberate because it can be used either way depending on the case. The likelihood of documents with probative value existing. So, no matter how complicated your case is or how valuable your case is, If it's unlikely that you're actually going to get any documents, then the court will not make an order for extended disclosure, particularly search-based extended disclosure, because it will be a waste of money. And they are with probative value which undermine or support a party's case. So this kind of generally, this concept I think that we used to have, which is that you would disclose anything that was kind of generally relevant, has gone. Now the court is very much focused on documents which either undermine or support a case. It was also, will take into account the number of documents involved. Clearly, if there's going to be a lot of documents, then that's likely to weigh against you. The ease and expense of retrieval of any particular document, that can particularly come into play with electronic documents, of course. The financial position of each party, and the extent to which they can afford to pay for all this, I suppose. And the need to ensure that the case is dealt with expeditiously, fairly, and at proportionate costs. And there is a hot off the press decision. It really is hot off the press. Fresh? Isn't it fresh? Because it's only 8 days old. It was handed down on the 13th of April 2021, and it's called the Performing Rights Society in Qatar Airways. And it's 2021 square brackets EWHC 869 round brackets CH. And I think what's interesting about this is that I've looked at quite a lot of these offshoot satellite litigation about the disclosure pilot, and they often involve entities which have the name Qatar in them. I don't know why that is. But anyway, so in that case, it was Deputy Master Francis, and basically he did a kind of issue by issue analysis of reasonable and proportionate and the 7 factors, and he concluded that a disclosure exercise which was going to cost each party about £250,000 would be proportionate, because each party had lots and lots of money. So why not go for it? So yes, so you can see that, you know, what might be felt by some to be reasonable and proportionate may in fact, you know, on the face of it, be a very expensive exercise. In that case, I mean, you know, it's a high value case, but nonetheless, I mean. So Rosie, then, what's an issue for disclosure?
Thank you very much, Jordan. Just before we get to what an issue for disclosure is, I just thought it might be worth flagging something that came up in a case I was involved in recently, which is that although you generally ask for extended disclosure at a CMC, so, you know, you might think you can rest on your laurels and wait until the CMC to sort of hammer out what you say the issues are and what you want disclosed. There is actually a pretty scary timetable set out in the disclosure pilot for when you need to liaise with the other parties to identify what the issues are and start filling in the disclosure review document. So it's worth checking up on that after you've done exchange of statements of case, because you don't want to get caught on the hop because you know, it's 7 days before the CMC and you think, oh my God, I have to fill out this enormous disclosure review document. So on that cheerful note, what is an issue for disclosure? I think it'd be fair to say that in my and Jordan's recent experience, this is often something that is a particularly right ground for argument, because issue for disclosure actually has quite a specific and perhaps rather niche meaning. And in essence, what you have to be careful with issues for disclosure is to differentiate them from just a legal issue or an issue that will need to be determined at the trial. Because an issue for disclosure, sorry, I've said issue too many times and now it sounds weird. An issue for disclosure will almost never be a legal issue, like, for example, what does clause 8 of the contract mean? An issue for disclosure will generally be a factual issue, and it always has to be an issue which needs to be determined by reference to some documents in one or other party's possession, but not in the other party's possession. So for that reason, an issue for disclosure, for the purposes of asking for extended disclosure, will not include an issue which can already be resolved by reference to documents that both of the parties have. So, as you can see from the excerpt on the screen, it is really the documents that are front and centre here. In McParland, which I think I mentioned on a slide a few slides ago, Sir Geoffrey Voss, him again, said that the right way round was, in essence, to think about documents before issues. So you have to think, what is the relevance of documents or categories of documents likely to be, you know, what is the relevance of those documents likely to be in the other side's possession to the contested issues in the case? So, you know, you're thinking about what are the likely documents in the attic and what are they relevant to? You then go on to identify the issues for disclosure from there. What you are not supposed to do, in theory, is to simply go through the pleadings and say, well, that's an issue, that's also an issue that will arise at trial, and try and do it that way round. Although, of course, in practice, it does tend to be a bit more mixed than that. I think perhaps you can overstress the distinction on a sort of a theoretical level. The last point I've made is, can an issue for disclosure be anything other than a pleaded issue? And that is, again, something that has been litigated pretty recently in sort of satellite litigation terms, and is the subject of two conflicting decisions. The first one, Lone Star, the judge's view was that an issue for disclosure has to be an issue that is crystallized in the statements of case. So that's an obvious concern for practitioners when putting together the statements of case, because if that's the case, then you don't want to miss out something that you may later want to get disclosure for. But the position is essentially in flux at the moment, because in the later case on the screen, the judge said, well, actually, no, I disagree. Issues for disclosure don't have to be derived from the pleadings. In fact, there's nothing in paragraph 7.3 that suggests that they do. Instead, when you're looking at an issue for disclosure, it simply has to be an issue, and usually a factual issue, as I said, that needs to be determined in order for there to be a fair resolution of the proceedings as a whole. It's not so limited as to the pleadings. So, I mean, I suppose watch this space, because I anticipate this is something that will continue to be argued about.
Yeah, I should say as well on that, what is emphasised quite a lot on these kind of applications and for extended disclosure and formulating issues for disclosure, is that the issue should be so formulated. I think the test is, and I can't remember the judgment, but the test is that a reasonably competent paralegal with knowledge of the case would know whether or not an issue, whether or not a document did fall within the issue. So when you're looking at your issues for disclosure, you know, although you shouldn't be too granular, you also, I guess, shouldn't be too vague.
Yeah.
Which is a difficult. I mean, because in one breath the court's saying don't be too granular, but in another breath they're saying, oh, you should kind of readily. Someone with legal training who'd read into the case could readily understand whether something applies to it. So it's quite a difficult balancing act in practice, I think, defining your issues.
Exactly.
Which I think is highlighted by the next slide. Well, so, examples. Yeah, I mean, I recently had a proprietary estoppel claim where the difficulty is with proprietary estoppel issues in relation to lots of issues in the type of work we do, is that there isn't a kind of broad distinction between issues of fact and issues of law. So, for example, in proprietary estoppel, you know, you could simply break it down to the constituent parts of a proprietary estoppel claim. But if you say something like, have they suffered detriment, then that can become quite difficult. And I had an argument in front of Master Clerk the other day about whether or not that was a suitable, I mean, it wasn't quite so broadly framed, but it was essentially framed like that, whether or not that was suitable, because it was said that that was an issue of law. But in fact, it's really an issue of fact when it comes to disclosure, because, you know, how else can you frame that, really?
Yeah, I had a similar argument in a case, which was sort of running alongside Jordan's, also with proprietary estoppel. And it's, as Jordan says, there's a really difficult balance between being really granular and then being too broad and just focusing on the pleaded issues, which is what we're told we're not supposed to do. Because I suppose you could break down detriment and say, well, if it's a farming dispute, and the issue is whether the claimant actually drew profit from the farming partnership, contrary to what he's alleging, which is that he didn't get any benefit from it at all, then I suppose you could frame it more narrowly and say, well, to what extent or did X benefit from the farming partnership in 2009 or something? But then I think there's a risk there with being too granular. And I think possibly this is, again, something that has to be the subject of discussion and negotiation with the other parties.
I think that's right. Although I think what can be depressing, if I put it that way, it's not depressing. I mean, I suppose it's in the spirit of the thing, but this is very much a court-led process, or it's supposed to be very much a court-led process. And I think the training that has been given, the judicial training that's been given to the masters and the judges who are applying this in practice, is not to do what was previously the case. Because, of course, you know, previously, if you agreed an order at a CMC which had standard disclosure or even orders for specific disclosure, the court would essentially rubber stamp it and say, well, if the parties are happy, then that's fine. But now, and I guess this follows on from, you know, the whole thing about cost budgeting and stuff like that, this idea that the court should be controlling its own process in a way that it previously didn't, is that actually, you know, in several cases that I've had, we have agreed issues of disclosure and the court has said no, even if we've essentially agreed the order, because the court is looking for, you know, to make sure that you are following this. So you can't just all be like, oh, we all prefer standard disclosure, so let's just do an order that's essentially standard disclosure, because the court will stop you doing that.
Yeah, but then by contrast, and I've had another dispute recently where we were very keen to comply with formulating issues for disclosure and making sure that we did it to the letter. And then the deputy master we had just didn't really seem to care. So I think there's still not really a consistent approach being applied. And that's what's a bit difficult for practitioners, I think, because you sort of think, well, am I going to spend all this money complying with it to the letter as we're told that we should, only to get to a judge who says, well, let's just order whatever approximates to standard disclosure because everybody sort of knows what that means. But then I suppose we're now getting into what we were going to discuss at the end, which is how does the disclosure pilot work? So I think it's useful to perhaps just use one of the other examples from the screen in relation to an executor removal claim, because I've had a similar argument in relation to that. Because an opponent that I had in one case said, well, obviously the issues for disclosure are, should the executor be removed and should the executor be replaced? And I said, well, I don't think that's an issue for disclosure. That's you know, that is a typical example of a legal issue, because how is an intelligent paralegal supposed to know what documents are relevant to that issue? I mean, do you agree, Jordan? I just think that's an absurd defining an issue for disclosure.
Absolutely. I think that that the those kind of things, they're definitely. I think what you also need to do, and what the court keeps emphasising, is get away from this idea that you will have, this is a different list of issues than what we previously referred to as a list of issues. So a list of issues for disclosure is not the list of issues for trial. And I think there's still a tendency of people to think, oh, let's agree a list of issues that will, for all purposes. But actually, when you look at the disclosure pilot and the way that the court applies it, you do have to think quite carefully about your list of issues for this. You know, it's not the usual one size fits all approach.
No, I think you do need to be much more careful. So should the executor be removed is obviously a legal issue, whereas I suppose what you'd want to do if you were seeking disclosure in relation to an executor removal claim is restrict it to much more factual issues. Might be something like, did the executor account for the proceeds of sale of X property or something like that? But even that might be construed as being too legal, because
that's right. But I think you have to be very careful as well, because I think it's fine to start with the pleadings, but this is your only shot, and because you're doing it via a list of issues, you can't have that safety net that you would have got previously with a standard. Even if you get Model E disclosure, you're going to get Model E disclosure with reference to a list of issues, and you won't have that safety net that all basically relevant documents will come out at one time or another, and then you can amend. At this stage, you really have to be very careful and think, is this going to catch all of the documents that would help me?
Yeah.
So I think the issues for disclosure is possibly the most difficult, as you can see by the fact that there are conflicting decisions, and the fact that Rosie and I are discussing it, but also the most important in lots of ways to get it right, because there's no point in having Model E extended disclosure, which is essentially the old standard disclosure, as Rosie will go on to discuss. But there's no point having that a broad, extended disclosure order with reference to a list of issues if that list of issues is not sufficiently well drawn to catch the documents that you will need. And that can be particularly difficult in something like a proprietary estoppel claim or a probate dispute, where you're looking, at a broad. You can be looking at a course of conduct that's gone on over many, many, many years. Proprietary estoppel, we've got pictures of cows there. Not most, but a lot of proprietary estoppel claims that we deal with are farming proprietary estoppel claims. And the course of conduct, tends to literally be the course of someone's adult life.
Yeah.
And so, it can be particularly difficult to not just say, did the claimant suffer detriment? Did the claimant rely on the promises, etc.? Were the promises made?
Well, also because what Sir Geoffrey Voss says is that you have to look at what documents might be likely to be in the other side's possession with a view to framing the issues by reference to that, rather than by reference to the pleaded issues. But if you don't know what documents the other side are likely to have, because they're lay executors who may have absconded with the proceeds of sale of a house, but you just don't really have any idea what they might have, then it can be quite difficult to try and do it that way around. It's a bit of a mental exercise.
Absolutely. Okay, fine. Should we move on?
In typical form, not answering the questions we've actually posed.
Exactly. What is? I think it's all going to depend. It's
very fact sensitive.
Yeah, it is very fact sensitive, but I think that does highlight actually that the whole point of this now is everything is supposed to be tailored to the particular case. The case's value, the importance of the case, the particular issues that are raised in that case, as opposed to the one-size-fits-all approach, or what was felt to be the one-size-fits-all approach under CPR 31. Right. I believe you're next, Rosie.
I think I am, yeah. Okay, so taking it very briefly, because you can all read the disclosure pilot, and I don't want to just read the disclosure pilot out to you. We have the disclosure models. The models are from A to E, and in essence, they go as you proceed from A to E, you start getting into more disclosure. So as Jordan said a few minutes ago, models A and B are very limited indeed. Model A is just disclosure limited to known adverse documents. Model B is called limited disclosure, and it's effectively the same, but it's sort of amalgamated with initial disclosure. So if you think that proper initial disclosure hasn't been given, then you might look at Model B, because it effectively reiterates the provisions in relation to initial disclosure. When we get to Model C, it's getting a little bit more exciting, because it is request-led search-based disclosure, fun. And then finally, Finally, dealing with models D and E. As Jordan said, model D is effectively standard disclosure, where a party is obliged to disclose documents likely to support or adversely affect its claim or defence, or that of another party. So we're on familiar ground here, because it's effectively the same as standard disclosure. But here again, you have the limiting factor that it is disclosure, standard disclosure effectively, but in relation to one or more of the issues for disclosure. So again, the key thing here is that it is by reference to the issues for disclosure. And finally, Model E is wide search-based disclosure, and that is train of inquiry, which again is something we're familiar with from Part 31. It's possible to have different models for different issues for disclosure. It's very tailored, the disclosure pilot, or at least that's the aim. So if you think you need Model E for one issue and then Model C for another, then that is absolutely fine and in fact rather encouraged. And leading on from that, as we've already said, the court's no longer just going to make a global standard disclosure order. Although, as I said, I had a case quite recently where that is effectively what the Deputy Master did, I think, because he just was a little bit disillusioned with the disclosure pilot. Moving on, thank you, Jordan.
Yes, so what happens next? So if you've got your order, or you've had, you didn't want it, but you've got it anyway, your order for extended disclosure, you then have to fill out your disclosure certificate, which has to be substantially in the form of the fourth annex to the new streamlined document. And that has to be accompanied with a statement of truth, which is signed by the client, essentially, that all known adverse documents have been disclosed by the party. So it's this idea. I mean, it's possibly not that, that I think people thought that it was going to be much more shocking, the idea that you'd have the statement of truth, but it's not that different from the old system. And then you've got a list of documents, which is very much like the previous thing. And then you've got production of documents. And it's interesting here, you don't have the inspection stage, you don't have requests for inspection. You're supposed to just produce the documents with your list. And if a document can't be produced, either because it no longer exists, it's no longer in the possession of your client, or for any other reason, you have to describe the document and explain the circumstances in which it ceased to exist, left your client's possession, or any other reason why you can't produce it. Electronic documents have to be, unless you agree otherwise, disclosed in native format, and hard copy documents, either photocopy or scan. So, I mean, it's odd that it feels that it needs to say that, but you don't have to give the original. No surprise there. So, and then if you don't comply with your extended disclosure order, things have the way the court deals with it is perhaps slightly different than it used to, which is that it will take a kind of a more it will drill down into what's necessary more than it would used to, because of course if you didn't previously comply with an order for standard disclosure, you'd either get some kind of less and less order if it was a really kind of root and branch failure to comply, or a specific disclosure order. But now the court's suggested powers are this: the court can either order to serve a further or revised disclosure certificate. I'm not quite sure how that would help, but anyway, undertake further steps, including more searches to comply, so it can direct you to take specific actions that it thinks you haven't already taken, provide a further or improved list, to just produce documents. I suppose the production of documents there is intended to capture circumstances where you're purporting to withhold a document for another reason, and this, I've had this on at least one occasion now, make a witness statement explaining any matter relating to disclosure. And again, I think this is the like the statement of truth on the disclosure certificate, is intended to police by the use of statements of truth that disclosure has happened properly. If the court's not satisfied that you've done it, it's going to make you say that you've done it with a statement of truth. And of course, if you are lying, having signed something with a statement of truth, and the consequences are much more severe than just simply having lied in a general kind of way. But as I've said, the party applying for the order must satisfy the court that it's reasonable and proportionate, and that's in the same way that the same factors are taken into account as at the getting the initial extended disclosure order. So if you want an order upon failure to comply, you've still got to satisfy the court that it's reasonable and proportionate to have that order made. The court can at any time vary an extended disclosure order, and the party applying for that variation again must satisfy the court that it's reasonable and proportionate, and also necessary for the just disposal of proceedings. Because obviously, I mean, essentially something has to have changed as to why you would vary the extended disclosure order at that particular point. So Rosie, I should say as well that under as well as what I've just go back to the previous slide, as well as those kind of general things, the disclosure pilot does make clear that the court retains, and it makes this very clear in terms, the court retains its full range of sanctions, including unless orders, strike out, other case management powers, etc. And if you've been really naughty, contempt. And the disclosure pilot does make that clear in terms. So, I think this is intended to say, we're taking disclosure seriously now, guys. So we all have to do that. So Rosie said earlier that one of the problems is that the provisions can be quite complicated and involved, and that does lead to an area of dispute. Well, luckily, the disclosure pilot provides a mechanism for that, which is these disclosure guidance hearings.
Thank goodness.
Thank goodness. And you seek guidance, and it's guidance and no more from the court by way of short discussion. So you just rock up to the master and you have a little chat concerning the operation of the disclosure pilot. But the court will only order it if the parties have made real efforts to address the issues between themselves, that the issue is suitable for guidance rather than a ruling, and that it's maximum 30 minutes for pre-reading and 30 minutes for a hearing. And the good thing about disclosure guidance hearing is that because it's 30 minutes hearing, 30 minutes pre-reading, you can get them pretty quickly. So it's much quicker than getting a normal application heard. The legal representative with direct responsibility to conduct a disclosure has to be present for each party. Now, the unusual thing is once you've had your short discussion with the master, that's to be recorded in a short note to be approved by the court. So the master gives you some guidance, and you then approve a note. You draft a note which the master approves. But the court can make an order where appropriate. Now, I've done several disclosure guidance hearings, and in every single one, the court has made an order. So I don't know the extent to which the court is genuinely following the short note procedure. And in lots of ways, if the court has essentially resolved the matter,
you might as well
just make an order, because actually your note, which has to, they also have to say disclosure guidance hearings. The last one that I went to went on for nearly an hour rather than the 30-minute schedule. But, to get a note that both sides approve and then the master approves is actually a more time-consuming thing than to just draft an order. So the court does, in my experience at least, and perhaps that's unusual, I don't know, but the court does tend to make an order at disclosure guidance hearing. But it does say that the norm will be a short note to be approved by the court. And the general rule is cost in the case. And I guess the court can depart from that, and it probably would do in the right circumstances. But I think that the underpinning is therefore that if you seek a disclosure guidance hearing, you're not worried in the same way that if you make an application that you're putting yourself at risk as to costs. if you do that. So tell us, Rosie, are any aspects of Part 31 preserved?
Well, given that we're running out of time, and I'm conscious that we've already been speaking for 50 minutes on the disclosure pilot, I'm just going to say yes. Yes, they are, as you can see from the screen. And perhaps actually preserved was the wrong word for me to choose, because of course Part 31 does remain in force. It's just that where the disclosure pilot applies, Part 31 will not apply, save so far as specifically referenced in the pilot. And that's all very clearly set out in the pilot, although you have to hunt around for the sections of Part 31 that are specifically reproduced later if you scroll quite a long way down the disclosure pilot. But
yeah. It is under a heading called Section 2. So
yeah, that makes it really clear. And in fact, if you look at paragraph 1.9 of the disclosure pilot, it says, save for those provisions of CPR Part 31 that are set out in Section 2 and the related provisions of the practice direction, Part 31 doesn't apply. And we've summarised those on the screen. So in essence, pre-action disclosure, third-party disclosure, and CPR 3122, which doesn't really have a snappy title. So
I believe that we used to call that the what was it called? The implied undertaking, wasn't it?
Oh, the implied undertaking.
The implied undertaking, which of course is no longer implied and hasn't been implied for about 40 years.
Before we were even born, Jordan. So let's move on to the next slide, please, Jordan.
Yeah. Is it working? Does it really cut costs? Does it make things easier? It definitely doesn't make things easier in the sense that it front loads things, I think. So, you know, previously you would only really narrow down what the issues in the dispute were following disclosure and often following witness evidence. And that has really changed. So you have to have a handle on the case and not granular, of course, issues, but actually relatively granular compared to the previous thing at a much earlier stage. And, you know, so does that make it easier in the long run? In some ways it does, because, you know, once you've done it, it's much easier than it would have been previously, where, you know, you may have not really had a good handle on your case until much later in the process. But it, you know, it feels very front-loaded, I think.
It feels front-loaded, and I suppose that's a blessing and a curse, because it tends to front-load costs. And also I think, you know, you can't really doubt that given how complex the disclosure pilot is and all the steps that you're required to take between statements of case and the CMC and then afterwards, that it does feel like it will generate more costs than simply asking and acquiring an order for standard disclosure and doing it as you normally would have done. So I think perhaps that's because we're still in the teething stage and we're still having lots of arguments about what issues for disclosure are, and we're still getting accustomed to the disclosure review document. But at the moment, it does seem like it's increasing costs. But that said, perhaps the fact that it's front-loaded makes it easier to settle things at an earlier stage, because you've got more of an idea about what the documents are. Although I suppose that depends on how broad you've taken initial disclosure to be. And as we've discussed earlier, initial disclosure can be pretty limited. So I suppose the jury's out, really, isn't it?
Yeah, I think that's right. And I think in terms of cutting costs, it does depend on your case, because, you know, although it's supposed to apply to high value and low value cases, and it does in fact apply, it does feel very much like it's designed to have eliminated some of the problems in big commercial and also higher value kind of, you know, private client work that you might have, such as, you know, electronic disclosure, for example, in trying to limit that. Because if you get an order for standard disclosure in a big case, you know, the cost of electronic disclosure can be absolutely enormous. And it's obviously trying to limit that. The difficulty is that, you know, even in quite high value probate claims, for example, it can be a handful of documents that are relevant. but you still have to go through, you can't just say, let's have standard disclosure, because nothing, you know, you still have to go through all of the steps to get your order. And so I think it, you know, and at every stage you're thinking, oh, well, we got it right, etc. And I think that can be a good thing. But it does, whilst it's supposed to be tailored, in that, you know, in that very tailoring, it kind of feels like it's actually one size fits all, because it's subjecting all cases to a pretty rigorous process of identifying issues, etc., and, you know, considering in very minute detail what disclosure is necessary, etc. Whereas I do think in some cases it would be just easier just to go back to the old system, but it's obviously difficult to discern where that line is. But yeah, so there we are. That's my view, but yeah, jury's out.
I suppose if you really want to avoid it, you could just issue in the county court.
You could. Well, that depends on jurisdiction there, though, doesn't it?
Well, I mean, yeah, it does depend on jurisdiction.
And also that comes with its own problems, doesn't it? Yeah. So yes. So there we are. So I think our next slide says any questions, and we have had a question.
Have we?
We have. Have there been any suggestions of encouraging the court to order different types of disclosure, i.e., other than standard under CPR 31? Could models A to E be grafted onto that system to avoid the need for the disclosure review document? I mean, it could, in the sense that that might be a more preferable way of dealing with things than the disclosure pilot. But at the moment, you're stuck with the disclosure pilot. And in fact, I tried to argue in front of an unnamed master recently that we could use parts of CPR 31, and she said anyone who says that has only a passing familiarity with the disclosure pilot.
Oh, such done.
And I think what she was telling me is what is correct is that actually CPR 31 saved as, you know, specifically saved by section 2 of the disclosure pilot does not apply to cases to which the disclosure pilot case applies, which is basically all cases in the business and property courts now, apart from those, you know, apart from the narrowly defined ones, as you say, and Part 8, etc. So yeah, I think that I could see the sense in that, but at the moment that's not a possibility on a case by case basis.
Sad.
Would you agree, Rosie?
Yeah, I think I would agree.
Good. Well, that's our only question. So, and we have talked for nearly an hour on the disclosure pilot, and we were discussing that we'd only do half an hour because we could possibly subject all of you to a whole hour. So we apologise for that. Yeah, we do apologise, but I feel that we've barely scratched the surface, which is part of the problem with the disclosure pilot. Is it is actually, I know that it's kind of the wording that they use, but it is actually a sea change. But you know, we're getting used to it, I think.
Indeed.
Soon it will feel completely familiar, won't it?
Of course. We'll be, you know, living and breathing it.
Good. Excellent. Okay. Well, thank you everyone for coming.
Thank you very much.